A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards. Glad to be with you on the program today. Before we get to our interview with Chuck Michel, head of the California Rifle and Pistol Association, I should note, good news in North Carolina. I think good news. SB 50 passing out of the House. That is permitless carry. It has already cleared the Senate. It is on its way to Governor Josh Stein. It's going to get vetoed by the North Carolina governor, unfortunately, who is an anti-gun Democrat. And that is when the fun, quote-unquote, begins. As we've talked about with Paul Vallone of Grassroots North Carolina, it is going to be, I think, a bit of an uphill fight to override Governor Stein's veto. But Paul said in a statement yesterday that he has every confidence that the votes are going to be there. So Paul's going to join us next week on Cam and Company. I also want to give a shout out to the borough of Englishtown, New Jersey, for taking action last night at its council meeting, adopting a resolution that will return $150 of the $200 concealed carry fee to residents. The way the law is set up in New Jersey, it costs $200 to apply for a concealed carry permit. $50 of that goes to the state. $150 goes to the municipality where the person applies. And the borough of Englishtown, I think the first in the state to say these fees are unconstitutionally excessive. We're going to do what we can to alleviate the burden for individuals exercising this right. And so they're going to be giving back that $150 that Englishtown residents are having to fork over to the state in order to exercise their right to carry. That is huge. I've reached out to Dan Francisco, who is the mayor of Englishtown, and hopefully we'll be able to get him on the program to talk about it next week. But my colleague John Petrolino has a piece at Bearing Arms today talking about hopefully this being the first of many municipalities around the state of New Jersey that will do the same thing. And I hope, and I'm knocking on wood here, that John is right. All right. So with that news out of the way, let's turn our attention to today's conversation with Chuck Michel, head of the California Rifle and Pistol Association. We're going to be talking about some of the litigation that is ongoing in California and the litigation that's about to be filed in California regarding, again, abuses with the concealed carry system. $200 is bad enough to apply for a concealed carry license. But if you live in Santa Clara County, California, it's going to cost you $2,000 to apply for a concealed carry permit. A permit, by the way, that's only good for 2 years. Yeah, I know. Which is why the California Rifle and Pistol Association is getting ready to litigate over that. We've got some other updates, though. Interesting. One of the first lawsuits that CRPA filed over the excessive fees being charged has now been settled, with a California city agreeing to reduce its fees to a still excessive but perhaps more reasonable level. Anyway, we'll get into that with Chuck Michel, head of the California Rifle and Pistol Association. Take a look and a listen. Chuck, thanks so much for coming on the program. It's good to see you again, my friend.
Always a pleasure, Cam. Thanks for having me.
Absolutely.
Let's get the word out.
I'm always glad that you can carve out a few minutes here because you're a very busy man, a very busy litigator.
The last few days have been quite a hamster wheel, yeah.
Yeah, I mean, we've got briefs filed in the Seventh Circuit case, the Illinois gun and magazine ban case. We've got a little bit of news to talk about with the Duncan, but I want to start with something I saw on X from you just a short time ago. And back in March, you had hinted that litigation was coming in Santa Clara County, the city of Los Angeles. They did not get their act together, reduce the wait times, reduce the fees for applying for a carry license. Neither of those things has happened, and it sounds like litigation is imminent against those two jurisdictions there in California.
Well, we're absolutely against Santa Clara. That's coming probably next week, maybe this week. LAPD, they're making noises about changing their system and expediting processing, but right now it's still, they have 8,000 applications pending, and they're not even taking applications. You have a waiting list to just apply. So that's not copacetic.
Yeah.
But we're bringing some of the other jurisdictions who have streamlined their processes into the fold, like Riverside is Orange County. These are model jurisdictions that have their act together and get the applications processed fast. So they need LAPD and LA County Sheriff. They need to bring in these companies that have got these processes down to a science and have them help them get the process streamlined. Now, I don't trust LAPD or LA Sheriff for that matter because of their historical reluctance, not just reluctance, their hostility towards issuing CCWs. LAPD was sued multiple times over the years over their CCWs, fought that tooth and nail, never issued CCWs. LA Sheriff was just as bad, really. So I'm not going to trust them to say they're doing what they're supposed to be doing, until I see it in place.
Yeah. All right. Well, let's focus on Santa Clara then, since that lawsuit is imminent. Back in March, you and I wrote about this at Bearing Arms. The cost, just the cost to apply and obtain a permit from the county itself is about over $1,000, right?
$2,000.
When you add in the training, psychological testing, all that stuff, yeah, $2,000
for a 2-year permit.
Right. $1,000 a year, basically, to exercise your right to carry.
Who's got that? I mean, gun owners didn't create this cumbersome system. The state did.
Yeah.
And now it's a constitutional right. If you want to create a system that makes you do this much work, you got to pay for it. The applicant doesn't pay for it. I mean, for crying out loud, in other states, it's like $200 or less, and it takes, a week or two.
Yeah.
So it's not like it can't be done.
$50 for my Virginia permit. And then the cost of training, which was, I think, $89. And that's good for 5 years. So, I mean, you're right. And this is, as you say, it's not like this is some natural system. Like, well, it's just the way the world works. No, this is the system that the legislature put in place. But also, as you've talked about, Riverside County, Orange County, not every county is charging $1,000 to get a permit, right?
Right. And we're going to have a big fight. We just settled with Laverne because they reduced their cost from over $1,000 to like $250. And by the way, CRPA has a bill in Sacramento right now to extend the period of a CCW license from 2 to 4 years and the renewal to 4 years. So that would cut all of this in half.
Yeah.
But
so Laverne settled.
Yeah. And they're going to pay part of our fees too, because they're arguing that, look, we're only now charging what it actually costs us. In my view, $250 is still too expensive. I mean, I can afford $250, but a lot of guys can't. $250 a year. I mean, that's a relatively big bill in the grand scheme of things, monthly expenses. So the ultimate fight on these costs, and we're probably going to have it in the Santa Clara case, is can you even charge what it actually costs you? Because if you're doing it inefficiently, then it's costing you more, but that's not our problem.
Right. Yeah. And it's amazing that, I mean, Santa Clara is the poster child for this, given their previous history with Sheriff Lori Smith, convicted in a civil trial of concealed carry corruption, this pay-to-play scandal. I know that there was kind of a mixed bag in terms of prosecuting some of her underlings and some of the folks who were engaged in these briberies or these bribes. But I mean, the sheriff was convicted of corruption here for basically approving VIPs. If you're an average citizen and there was testimony to this effect, your application was put in a drawer somewhere and was forgotten about, right? That's what it was like under the May issue system. Then Bruin comes along, the May issue system goes away. Santa Clara officials have the opportunity to turn a new leaf, right? And to say, okay, listen, we're going to take this right seriously. And instead, nope. They impose one of the most restrictive and costly burdens on Californians anywhere in the state.
And this is what's happening out here. CRPA, and I got to give a hat tip to our strategic partners and alliances with Gun Owners of California, Gun Owners of America, Second Amendment Foundation. We're all watching, as part of the CCW Reckoning Project, we're all watching all these jurisdictions. And a lot of them, after Bruin came down, we sent letters saying, here's what you got to do now. A lot of them came around. Even San Francisco started issuing. But some of them are trying to play games. So they're not putting the resources in place to process the applications fast enough. They're trying to charge too much to discourage applicants. And then the state naturally passes its sensitive places law, which makes, all the places where there's never been a problem. For 100 years, there was never a problem with people with CCWs going into these places. But suddenly they go back and retroactively declare, a parking lot outside of a bar and dozens of other places to be sensitive where your CCW license is no good. So that's the games. That's the passive resistance that they're playing now. It's just another reason why we need SCOTUS to take a case and slap down some of these courts.
All right, well, let's go there. Speaking of SCOTUS, I don't think I've spoken to you since SCOTUS turned away the Snope and Ocean State tactical cases. You and I talked before about this. Ocean State was a interlocutory appeal. It was an appeal of a denial of a preliminary injunction. So I don't know why they kept that case for 15 conferences before denying cert, but Snope kind of surprised me. At that point, they had been considering this case in conference since December. It was fully briefed. It was tried on the merits. In fact, it was GVR'd after Bruin, right? It was one of those cases that was up before the court. Court sent it back down to the Fourth Circuit. And we've talked about that before. Three-judge panel heard oral arguments, waited over a year to issue its opinion. Before they issued their opinion, Fourth Circuit decided, now we're going to take this case en banc, and then upheld Maryland's bans. This has been a screwy case all along.
Yep.
But then the Supreme Court, denies cert. Justice Thomas has this great dissent. Justice Kavanaugh has a statement, not really explaining why they denied it, but saying that he expects that the court will take up a case dealing with a hardware ban in a term or two. So I was asking you open-ended question. What was your reaction to the Supreme Court's decision to reject Snope and what Justice Kavanaugh had to say?
Hey, man, I want instant gratification, but instant gratification even takes too long when it comes to Second Amendment rights. Come on. What do you mean the next term or two?
Right.
But I understand they're flooded with Trump emergency appeals. Their shadow docket is swamped. But still, come on. It would be next session anyway. It wouldn't be this session that you would get the briefs on this. So who knows what's really going on? It might be the Trump cases that they're processing. It might be that they're nervous about the politics of a quote unquote assault weapon case. The magazine cases, the DC and the Rhode Island, were not fully developed. Snopes, maybe they saw some imperfections in the Snope record. Bottom line is, though, if Kavanaugh had voted to take the case, there'd be four. It only takes the four to take it. They would have had to take it.
Right. And Kavanaugh's statement talks about how, the Fourth Circuit probably got it wrong. He didn't come right out and say, I would have voted to overturn the decision, but he laid out all of the... He
cites to his own opinion in Heller, too.
Yeah. And since then, we also had Smith & Wesson versus Mexico come down. Unanimous decision authored by Justice Elena Kagan, upholding the Protection of Lawful Commerce and Arms Act, throwing out Mexico's lawsuit. And in that opinion, Chuck, Elena Kagan talked about AR-15s being the most popular rifle in the country, right?
Yep.
She talked about how...
For lawful purposes.
Yeah, and she said, listen, maybe the cartels like these guns, but so do a lot of civilians. And we don't just because a criminal likes a gun, we don't say, well, that automatically means that these guns are suspect, right? Or these guns are somehow nefarious. I was pleasantly surprised to see Justice Kagan write that. And again, to me, that makes the point that gun owners have been making all along, that bans on AR-15s are unconstitutional, in part because they are in common use for lawful purposes, which means they are not dangerous and unusual.
Correct. And that's I'm not sure that Kagan really realized what a concession she was making there, because all the states that are defending semi-auto bans, they all argue that AR-15s are not in common use for lawful purposes by law-abiding citizens, that AR-15s are overwhelmingly the choice of criminals, that AR-15s only serve military purposes, and you shouldn't put military arms in the hands of civilians. All of this stuff that in 2 paragraphs, she threw that out the window.
Yeah.
So we put that in all the briefs in the Illinois cases, immediately to bring that, because Easterbrook. Oh, and here's an interesting fun fact to know and tell. Easterbrook is the one who's leading the charge to strike down Illinois, to uphold the Illinois bans.
This is in the Seventh Circuit, Judge Frank Easterbrook.
Yeah. Easterbrook wrote an opinion that says when the Supreme Court says something in dicta, which arguably is what Kagan's language was. It wasn't really part of the holding; it was part of the reasoning, kind of. Even if it's dicta, though, Easterbrook, in his opinion, says that's pretty close to binding precedent. So we cited that right away. Hey, Judge, you're the one who said that this stuff that she just said is supposed to be taken very, very seriously.
Yeah.
So it's going to be interesting. I wish I could say it was fun because there's too much at stake for it to be fun, but it's going to be interesting to see how the Seventh Circuit processes that.
So let's talk about that for a second, because I know that it's confusing to keep track of where all these cases are. The Seventh Circuit cases, the challenges to the Protect Illinois Communities Act. Judge Stephen McGlynn has heard that case. He's decided that case on the merits. He permanently enjoined the Protect Illinois Communities Act, right? He ruled that it was unconstitutional. Yep. State of Illinois appealed this to the Seventh Circuit. And now you guys are going through briefings ahead of oral arguments. Have oral arguments been scheduled before the Seventh Circuit yet?
No, they're probably going to be in September.
Okay. So they're coming up pretty soon.
The state still has to file its brief. We're filing Second Amendment Law Center and the Second Amendment Defense and Education Coalition, the Illinois 501c3 group, and both deserve your support, viewers, are filing an amicus brief this Friday. And a bunch of other people have already filed amicus briefs. But the briefs by the parties in the 4 different cases that are consolidated were all filed last Friday. Now, the amicus briefs get filed, then the state files its reply, then they schedule oral argument. So it's still, I know it's a slow burn, and it frustrates me as much as everybody out there that's watching. I know the process is slow, but it's a historical time for the Second Amendment, for the jurisprudence of the Second Amendment. I mean, and now that we see what the dissent said and what Kagan said and what Kavanaugh said, we know we're ultimately going to win. All the arguments to strike down AR-15, or even Kagan even referenced Barrett 50Ks, 50 calibers, which are usually bolt action. Or often bolt action. I mean, those are protected. And that's right, because it's not just about self-defense. This is another argument they make. But the only thing the Supreme Court said is that if it's in common use for self-defense, then it can't be banned. Well, that's not right. If it's in common use for hunting, target shooting, collecting, common use for any lawful purpose.
Including, but not limited to, self-defense. Right.
Self-defense. Right. Self-defense just happens to be probably the most important. In some respects, the most important use, but it also happened to just be what was at issue in Bruin and Heller, because you were talking about defending yourself in your home and then defending yourself in public. Yeah. So those cases dealt with self-defense, but those rulings did not say it's only self-defense. So that's another thing that the Kagan opinion, the Mexico v. Smith and Wesson opinion helps us with.
Absolutely. And I mean, so I mean, not only was that a huge victory for the firearms industry, but I think you're right. It is starting to build that record. Right, that the Supreme Court, when it does take up an AR-15 case, when it does take up a magazine ban case, perhaps Duncan versus Bonta, it can now reference itself, right? And the Supreme Court likes to do that. They don't just like to reference lower court decisions. They like to reference what they've said in the past. And now they've got that record in Smith and Wesson versus Mexico, where, again, Justice Kagan acknowledges, where the court unanimously acknowledged. It wasn't just Kagan, it was Sotomayor, it was Justice Jackson, it was every member of the court acknowledging.
I wonder if they all realized what they were eating.
I mean,
but they should, because it's so obvious. This is what's said in Heller and Bruin. To try and deny that, as the states have done in defending against assault weapon law challenges, it's ludicrous. It's delusional. I mean, but some courts will twist their brains around to try and they'll bend over backwards intellectually to try and uphold the law. Yeah. And we've seen that again in court after court. But so are you? I mean, again, I think we're all a little frustrated that, as you say, we didn't get that immediate gratification or what passes for immediate gratification with the court. But it sounds like you are bullish long term on the prospects of overturning these bans when the court takes one. We are absolutely going to win. The Supreme Court just has to take any case. It doesn't even have to be a semi-auto ban case. All they got to do is set the methodology straight and say in common use means That's it. You're done. There's no further historical analog. There's no figuring out whether or not it's an arm that's included under the term arms in the Second Amendment. It's all conduct related to the possession of, repair of, use of, carrying of arms. I mean, once they make that, they clarify the test so that the lower courts can't twist it. Doesn't really matter what context they do that in. All of these cases where we've lost, they're all going to get reversed, or may have to file again. But we will.
Yeah.
As long as folks keep supporting the efforts, So help us if you can, folks. It's a historic time. Be part of history. Join CRPA. Join support the Second Amendment Law Center. Support the SADC in Illinois. Help us win. Help us bring it home. We are absolutely doing everything we can, working as efficiently as we can. All these groups get low nonprofit legal fee rates. So, get on the bus, because we're about to throw some gun laws under it.
All right, listen, I want to ask you one legislative question quickly before we let you go here. We've been talking a lot about litigation, but this maybe is a lawsuit in the future. The ban on, essentially the ban on Glock handguns has passed out of the General Assembly. It's over in the Senate in California. Do you think that gets to Newsom's desk, and do you think he signs it into law?
Well, does it get to his desk? 90% probability. Does he sign it? Weird new test to apply there. Is he trying to look centrist? Is he trying to position himself for a run for president? Maybe he doesn't sign it and then he brags about not signing it. Otherwise, if it wasn't for the fact that he politically wants to position himself that way, he'd be signing it in a second, because he never met a gun law he didn't like, a gun ban he didn't like. So yeah, he'd be signing it, but we'll see. And I know, by the way, the National Shooting Sports Foundation and other groups, they're already queuing up, including my clients. We're already queuing up to file a lawsuit challenging that if that law passes as well. So that's just one of the things on our dream sheet.
Well, I mean, Pritzker might have to make that same decision in Illinois, too, because they've got a similar bill there. And, he, too, has been rumored to be thinking about running for president in a couple of years. So,
yeah, Pritzker,
Right. So we'll see. All right. Well, as the Chinese curse says, may you live in interesting times. And that is certainly the case for us right now. Chuck, as always, my friend, thank you for joining me on the program. I always enjoy the conversations, and I look forward to doing this again very soon.
Anytime, Cam. Always a pleasure. Thanks for having me.
Thanks to Chuck for joining us on the program, and looking forward to having him back again here before long. Right now, let's turn our attention to today's armed citizen story, our good deed of the day, and our recidivist report. We'll start there with a case out of Corvallis, Oregon. Here's the headline. Grocery outlet customer body slammed over spare change. It's actually weirder than that. According to the, I think this is the Gazette Times in Corvallis, Oregon, a 55-year-old man named Clark Allen Boyd, indicted on felony counts of second-degree assault and strangulation in Benton County Court on Tuesday this week, also charged with misdemeanor menacing. The victim of this assault was with her husband. They were walking into this grocery store when they saw Boyd in the parking lot. I guess he was panhandling. Anyway, the woman offered him $5, which I don't consider to be spare change. But anyway, without words or warning, according to the paper, Boyd allegedly grabbed the woman, lifted her up, and then threw her on the ground twice. What's interesting here is this was, I guess, in August of last year. I don't know why it took so long to get an indictment here. But the police were called to the scene shortly before 5 p.m., August 26, 2024, on a report of a disorderly subject. According to an affidavit, the victim alleged that when Boyd grabbed her, he lifted her about a foot off the ground before throwing her down. She told police that she was afraid that her head would hit the curb when she was thrown, saying that she was afraid to move, so she just kind of went limp, landed on her shoulders, managed to cover her head. But then Boyd allegedly picked her up again and slammed her down a second time, this time allegedly stepping on her chest as well. Police observed bloody lacerations, abrasions on the woman's elbows and left hand, bruising and discoloration on her right wrist and the left side of her chest. The woman is about 5 feet tall, weighs just over 100 pounds. Boyd is 5'10", weighs about 160. The indictment against Boyd cites the victim's particular vulnerability due to her advanced age. Now, the paper in Corvallis says that court records show mental health evaluators found Boyd unfit to proceed with court in October. Details of his evaluation and treatment are sealed, but he was found fit to proceed in January, which may explain why the indictment took so long here. But they also note that Boyd has several open criminal cases in Benton County. So these are cases that have not yet been adjudicated. He's been arrested, but they've not yet been settled. Allegations of criminal mischief, harassment, disorderly conduct, trespassing, offensive littering, and harassment. He also has an open trespassing case in Multnomah County. That's bad enough, but he also has a litany of previous convictions, including multiple possession of meth convictions, failure to appear, assault, stalking, violating a stalking order more than one time, contempt of court, menacing, DUI, felon in possession of a firearm, and theft, according to court records going back to 1994. Boyd is currently being held in the Benton County Jail on $80,000 bail, which seems awfully low to me, given the long history of violent offenses for this guy. And again, I mean, this is Oregon, so, you know, as we've had stories from pretty much all 50 states, I think. And you can find these sweetheart plea deals in every state of the union. Oregon, though, at least until, well, I would even say now, I don't think they've fully turned things around. I think voters are getting fed up with the soft on crime policies in Oregon. But those very same voters enacted those policies, quite frankly, several years ago. And I think that, I suspect anyway, that those soft on crime policies may be one reason why Mr. Boyd has been the beneficiary of a revolving door in the criminal justice system. On to today's armed citizen story. Don't have a lot of information. This happened overnight in Atlanta. A man killed in apparent self-defense at Buckhead apartment complex. WSB Radio in Atlanta classifying this as a domestic dispute that turned deadly after a man was shot and killed in what police are calling a case of self-defense. So this would, again, appear to be fairly straightforward. Happened at the Cortland Peachtree Battle Apartments. Investigators say a man showed up at his estranged wife's residence. Atlanta Police Homicide Commander Andrew Smith says what we know at this point is this is a domestic dispute where the parties were separated. Commander Smith says the man entered the building, possibly with the help of somebody unknowingly holding the door for him, and then made his way to his wife's apartment where he confronted her. She, at the time, accompanied by two other individuals. Smith said often people will hold doors for individuals. There were 2 shots fired, and that the man's estranged wife and the 2 people with her fought back in self-defense. The man pronounced dead at the scene. No names have been released. The investigation is ongoing. He might not have even gotten to her apartment. He might have been waiting outside, maybe saw her in the lobby. But again, what we know is that it happened at some point in the building. Don't know who fired the shot to end the attack, but hopefully more information will become available. And, you know, we talked yesterday about these preventable incidents in terms of road rage, where, you know, you just take a deep breath, you move on, turn up the radio to your car, sing along, and you forget about the driver that ticked you off in a couple of minutes. We've seen enough of these domestic abuse stories. I know that that's not really the same thing, right? And I don't think I have to tell you this, but just let it go. Just let it go. If somebody leaves you, no matter how angry you are, do what Oliver Anthony did, write a song about it. But you show up with violence in your heart and on your mind, you may very well learn that your intended victim is able to fight back. And obviously, if you are in a position where you are afraid that your ex is going to do you harm, we've talked about this with Nikki Gozer before. Yes, take out a protective order. Do what you can to get the state involved, but don't solely depend on the state to keep you safe. Do whatever you need to do to protect yourself. If that means moving to a different location, if that means trying to hide your name, if that means getting a gun and knowing how to use it. Again, the important thing is for you to stay safe and for you to stay alive. Now, finally today, our good deed of the day in the right place at the right time, willing and able to do the right thing. A Webster City, Iowa man who saved a truck driver in Webster County, Iowa. And he says that he would do it all over again. Webster County road foreman Dale Isles was the guy who actually rescued the truck driver. This was on Monday. Isles said that the truck driver had crossed the center line, lost control of the bridge, basically jumped the guardrail. He said he was shocked to see it happen right in front of him, and as the semi-truck crashed and overturned, it burst into flames. The driver, a man named Clay Schmedicki, was inside the cab, and Isles says, when your adrenaline kicks in, you don't even think about it, you just start acting. So he stopped his truck, ran up to the semi that was already on fire, found Schmedicki, and told him, "You've been in an accident. Your cab's on fire. We got to get you out of here. Can you climb?" Schmedicki appeared to be in shock, which does not surprise me. When I was in an accident a little more than a month ago, I guess, and it wasn't even a serious accident, I was in shock because 1 second I'm driving down the road, and the next, my airbags have deployed. I got, the voice coming out of my speakers asking me if I'm okay. I didn't know what the heck was going on. But Schmedicki didn't say anything, but he was able to stand up, and Isles was able to help get him out of the truck as it continued to burn. Shortly thereafter, the truck actually turned over and then fell into the creek. So not only was Schmedicki saved from the flames, but he was saved from possibly drowning as well. He is taken to a local hospital, but he is already out and is expressing his gratitude, saying that Isles saved his life. For his part, Dale Isles says, I'd do it over again. He said, you just jump into action when something like this happens and somebody's wound hurt, especially with fire. He said, well, there's no time. You just jump into action. Well, that's true, I suppose, but, some people would freeze up. Some people would drive down the road saying, no, that's terrible, but it's somebody else's problem, or maybe I'll call 911, but I can't stop. I don't know what to do. So, no, you want to think that everybody would jump into action, but that is not the case. And so in the right place at the right time, willing and able to do the right thing. Dale Isles there in Webster County, Iowa, we thank you for your very, very good deed. All right, that is going to do it for this edition of Bearing Arms Cam & Company, and I do want to thank you, as always, for being a part of the program. Be sure to check out the website today, tomorrow, over the weekend. We're keeping you up to date on all of the latest Second Amendment news and information from all across the nation. And if you like what you see, I'd encourage you to become a VIP Gold, or VIP Platinum member. You'll get great benefits at every tier of support, but no matter which one you choose, you'll also be supporting the independent pro-Second Amendment journalism that we're doing at Bearing Arms, and we greatly appreciate your support. Use the promo code FIGHT, by the way. You can get 60% off your VIP Gold, or VIP Platinum membership. There you go. All right. We'll see you back here on Monday. Until then, be well, be safe, and be free.